My lord, the court proceedings are not audible, my lord. Much obliged.
Correct. ಸೋಮವಾರ ಬೇಡ ಬೇರೆ ಮಂಗಳವಾರ yes yes will be in dictation now free ಏನು Wednesday ಏನಾಗುತ್ತೆ
My lord, appear for respondent and
see one thing you are aware of it, I think of the facts. They are seeking for waiver of that interest. You had extended that waiver of Karasamadana till to 4th Karasamadana and 5 ಗೆ January ತನಕ March ತನಕ ಕೊಟ್ಟಿದ್ದೀರಾ. Then they are entitled to it. ಮತ್ತೆ Wednesday ಅಂದ್ರೆ see again we have to Monday we have lots of matter. So ಆಯ್ತು Wednesday same state. ಈಗ ಎಲ್ಲಿ ಲಾಸ್ಟ್ ವೀಕ್ correct it would be a small matter but we have so many further hearing. ಆಯ್ತು ತಗೊಳ್ಳಿ ನೋಡೋಣ if it's possible we will take it. Occurs ಬೇಡ page first ಬೇಡ page adjournment ಇಲ್ಲ. Now see, there are two contentions of yours. One is against the domestic inquiry. You were present on certain occasions, and later on you were aware that there was proceedings going on. Is it not? So very few. No. That is I have looked into the papers. I just tried to see whether you could be given some relief. But looking into that, he has been consistently, what? Correct. So the domestic inquiry cannot be held to be not fair and proper. Is it not? But then see, ultimately you would be entitled for filing raising a dispute. So,
then I'm entitled to a promotional application. We filed the promotional application. And particular workman status for that year, for yearly.
Correct. But that was not your contention.
Please, my lord.
So we will consider and pass orders, madam. No, again, see the reason is, from only the reason that we could pass an order today, we have listed this matter.
Please, my lord.
Please pass over.
My lords, I object to an adjournment in this matter, my lords.
No, pass over.
Okay, my lords, please, my lords.
Pass over.
see, may I?
Pass over.
With the lord's kind leaves.
No adjournment.
Number 2.
No adjournment.
ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಮಿಸ್ಟರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಮಾಡ್ತಾ ಇದ್ರು ನಾನು ಕೇಳಿಸ್ಲಿಲ್ಲ ಏನು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
Said he'll complete one matter for admission and he'll be coming here. We will take up this matter.
ಆಗ್ಬೋದು sir. Obliged.
Yes, why was it listed today? Was it heard? We see what happened. Yes. What should we do now, boss? But he's not a party. DCVC. Correct, we can do that. Now DCVC's instruction has to be secured by Jagdish. Ask him to be present. Ask him to be present today. Call him. At least he'll come through VCL. Yes, pass over. Let him pass. Again, to be listed on one more day, it is, you ask him to be present. See, all the while, or you tell Mr. Jagdish. You tell Mr. Jagdish that this court wants his presence. Comment order. Yes, you inform her. It's passed. Now 2:30 will pass over. Yes, what was this matter? Why was it taken like that? ಏನ್ ಮ್ಯಾಟರ್ ಇದು? ಏನ್ what material fact age? Order of termination. That has been dismissed.
So yeah, the question was different. You know, he has reached declaration long back. Please from henceforth on pension and expiring normal minimum pension and the other. There are judgments of Supreme Court where they say.
First, we have to hold whether the termination is proper or not, right? In the event, this court holds that the termination is proper as held by the labor court, then will you be entitled for all these benefits? Then,
The court
which
holds
is
that
correct. If at all you want to settle,
effect is employment. Because
what
he
was
still
his
holding a
separation?
driver. Although he said it in the police department.
Why they ask all the details of previous employment? Reason is they should get.
Educated ಅಲ್ಲ ಬೇರೆ ಯಾರೋ ಬರ್ತಿದ್ದಾರೆ ಅಂತ IAM ಅಲ್ಲಿ ಬೇರೆಯವರು ಯಾರೋ ಬಂದು ಅದಕ್ಕೆ ಸಹಿ ಮಾಡಿದ್ದಾರೆ.
We will be knowing that he was working somewhere. ಹೇಳ್ತಾನೆ ನಾನು ಇಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ. ಈಗ ನಿಮ್ಮ ಮನೆಗೆ ಯಾರು ಬಂದ್ರೆ you will definitely ask him, right? Where were you working earlier? And if he does not disclose that fact, what happens then? Reason correct. ಆಗಂಗಿಲ್ಲ ಎದಕ್ಕೆ ಆಗಂಗಿಲ್ಲ? We are not aware what has been transpired before the earlier employment. For what reason? Now, if there was an accident in his previous employment, definitely they would have not, or they would have thought twice before making an employment of this. Alva. One day, no accident is very serious. Alva. Otherwise, if you want sit across, I don't think Saukar sir will say no.
Because IAM
Saukar ಎಷ್ಟು ನೀವು ಅಮೌಂಟ್ ಹೇಳಿದ್ರೆ ನಾವು ಹೇಳ್ತೀವಿ ಅವ್ರಿಗೆ.
ಅಮೌಂಟ್ ಏನು ಬೇಡ ಬೇಡ.
ಅದೇ ಪೆನ್ಷನ್ ಎಷ್ಟು ಅಂತ.
ಪೆನ್ಷನ್ ಏನಿದ್ರೆ
ಈಗ ಕಡಿಮೆ ಇದ್ರೂನು ಅಂತ ಹೇಳಿದ್ರ ಎಷ್ಟು? Correct. We cannot direct them to give you pension. They can give you some amount in light of a termination that you can keep in a fixed deposit, take it as a pension. No, because if you direct them to give pension, it would be as good as
whatever may be the amount, they themselves.
Until you give a figure, how are they supposed to? ನಮ್ದು ಬೇಡ ಅವ್ರಿಗೆ.
ಅವರೇ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು ಸಾಕು. I am happy with that. ಯಾಕಂದ್ರೆ ನಾನು ಹೇಳಿದ್ರೆ ಜಾಸ್ತಿ ಅನ್ಸುತ್ತೆ.
Just stop. ಬನ್ನಿ ಶೇಖರ್. ಎಲ್ಲಿ ರೇಣುಕಾ ಮೇಡಮ್? Saukar is kind enough. He will.
ಕೊಡಕ್ಕೆ
ಕೋರ್ಟಿಂದ ಬರಲಿ ಅಂತ ಹೇಳ್ತೇವೆ.
ಬರ್ಲಿ ಅವ್ರೆ. Yes, Mr. Shekhar, what is this? Ex parte award? Set aside ಹೋಗ್ಬೇಕಲ್ಲ ಅವರು? Not represented. What is the amount? What is the misconduct? Absence, ಏನ್ ಆರ್ಡರ್? ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. Back wages ಕೊಟ್ಟೆ ಏನು? You have already worked, you have already got the salary. Now benefits also you have received? Only salary bantu for reinstatement. When did you attend superannuation? ಅಂದ್ರೆ ಇಲ್ಲಿ ರಿಟ್ ಹಾಕೋಕ್ಕಿಂತ ಮೊದ್ಲೇ ಇದಾಯ್ತಾ? 2014-18 ನಲ್ಲಿ ಬಂದಿದಾರಾ ರಿಟ್ ಅಲ್ಲಿ? ಅಡ್ವೊಕೇಟ್ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ರು. ಎಸ್ ಮೇಡಮ್. Where is madam? She is arguing a parted matter. She is already on her legs. Pass over ಮಾಡೋಣ ಬರ್ಲಿ. Ask her. She'll come after completion. Let us see. Superannuation ಯಾವಾಗಾಯ್ತು? 2016. Yes. Yes, pass over ಬರ್ಲಿ ಅವರು. You tell madam. ಇದರಲ್ಲಿ ಏನಾಯ್ತು? Letter from reference rejected. ಏನು misconduct? He's still in service. Superannuated. Absenteeism ಎಷ್ಟು ದಿವಸ? ಆಮೇಲೆ ಬಂತಲ್ಲ. We have received this ಅಲ್ಲ. We had directed the registry to secure the record. Yes. ಅಲ್ಲ ಈಗ absenteeism ಎಷ್ಟು ದಿವಸ?
Which is a particular charge, 26,000.
No, because we thought we are not having other matters, so we listed. ಅಲ್ಲ ಇದರಲ್ಲಿ ನೋಡಿ ಇನ್ನೊಂದು 6th ಮ್ಯಾಟರ್ ನಲ್ಲಿ he is already superannuated. No, in light of ಅಲ್ಲ now he's already superannuated. You have come with a delay of 4 years here. Correct. What is the hello? What purpose would
having that in background.
What purpose will be served now? What purpose after remand also? How far they will contest also?
Only on unauthorized action. Your document kindly place it on record. The issue will be only on consultation. This is entitled because I am ready to give the benefits without consultation. Even here, in fact, I
because
joint memo also. Try to do our
yes, what you say, Mr. Shekhar, for that? ಈಗ ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಟ್ಟೇ ಇಲ್ಲ ನಿಮ್ಗೆ ಅಲ್ವಾ? Not granting of back wages.
Continuity and consequence considerations that came on here. We did some
even cashment. Not one case, even cash. My person will take cash.
You can waive leave encashment ಬಿಟ್ಬಿಡಿ ಅದು ಬಿಟ್ಟು ಮತ್ತೇನು ಅವೈಲಬಲ್?
2 years benefit, 2 years can cover.
Leave encashment he has been absent for continuously for 2 years. ಅದಾದ್ಮೇಲೆ ಮತ್ತೇನ್ ಬೆನಿಫಿಟ್ಸ್ ಅವೈಲಬಲ್? ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಬೆನಿಫಿಟ್ಸ್. No, that you don't give. That exclude ಮಾಡಿ. See whether something can be given now that is already superannuated. Correct. Award. That you can remove and then see whether he can be. ಅಷ್ಟು ಬಿಟ್ಟು ಬಿಡಿ. Now he is agreeable now. Now he is agreeable. Now you are agreeable, right? ಅಲ್ಲ ಬರುದಿಲ್ಲ, ಹೆಚ್ಚ ಕಮ್ಮಿ ನೋಡ್ಕೊಂಡು ಯಾವ್ದಾರ ಒಂದು ಬಿಟ್ಟು, ಬಿಕಾಸ್ ಲೀವ್ ಎನ್ಕ್ಯಾಶ್ಮೆಂಟ್ ಬರಲ್ಲ, ಅದರ್ ಸಮ್ ಒನ್ ಬೆನಿಫಿಟ್ ಬಿಟ್ಟು ಒಂದು. So if at all, ಈಗ only because in this matter he is already superannuated. He says he is not. Till the date of award. ನೋಡಿ ಮಾತಾಡಿ. That ಇದು ಯಾವಾಗ ಹಾಕೊಳ್ಳೋಣ? ಮಂಡೇ. Both the councils suggest that there is possibility of settlement. To report settlement list this matter on Thursday. ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅಲ್ವಾ? ಈಗ 7 ಏನು? ಅಲ್ಲ ಇವರು unauthorized absence. I think that has been received. ಇದೆಯಾ ಅಂತ? If, is it any possibility here in this matter also? What is the misconduct? Absent. ಎಷ್ಟು? ಆಯ್ತಾಯ್ತು. Tuesday. Tuesday. Yes. Tuesday. We have some further hearing matters.
I asked him that without asking.
Okay.
So I thought Saturday is Parade and case. I said please post it on Saturday, come for all this. Then he told me but after the case.
I told him, Shekhar, we are listing all your matters. See, on that day, don't make this court go early. Yes. Yes. Just see if that get collapse, you can come back. And ಹಂಗೆ ಇರ್ಲಿ, our matter 7 matter ಹಂಗೆ ಇರ್ಲಿ, pass over ಅಂತ ನೋಡೋಣ. Yes. Which another matter? 10 Tuesday na? ಇನ್ನೂ 2 ಇದೆ ಅಲ್ಲ? That Shrikant Which one?
The other two is, the last is, which, takes some time. So, 21.
21. 21 bad ivre. 21 ಹೊಸದಲ್ವಾ? So Tuesday. No, Tuesday. And 20 also Tuesday?
Difference in also.
Yes.
I know, cannot say the time.
Yes, yes.
This much of
Yes, yes. Yes. Idu, Mr. Shekhar, your matter Harish Bhandari. Harish Bhandari is stated to be unwell. Is this matter on? Tuesday. ಆಮೇಲೆ ಅದು ಹೋಯ್ತಲ್ಲ ಆಮೇಲೆ ಲೋಕೇಶ್ he is only there. All Harish Bhandari. Mr. Lokesh. Breathing issue.
Subsequently, one is also granted. Persons are on now receiving funds.
He is not there in that. No, Harish Bhandari is there. Okay.
Voting is a rejected application.
Correct, because in his absence.
I just am requesting to remain to consider the latest notification. That's all. And even the authority.
File for it. If Harish Bhandari's absence is okay, we will dispose. Otherwise, if his his presence is very much necessary, we cannot pass him.
As far as voting is concerned, they can be heard before the authority also. It is just a fresh renewal application has to be considered by the authority.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ಇದು ಒಂದು
Authority has granted 4 renewals. 2004.
now what is challenged now by you? What has been challenged?
Application has been rejected by the authority and dismissed by the tribunal and before this tribunal. It also
Correct. There was a delay in seeking for application.
Moreover, whenever the notification is there, section 98 of the motor vehicles overrides chapter 5 and any other law. Wherever scheme notification is there.
No, the appeal of yours has been dismissed on the ground of delay, right? 2004. And when was this application filed?
For the reason, in view of the notification is there.
How many years? 1 year, 2 years?
Even with another entrustment, I have given more than 20 years it was considered. Even 2020.
Renewal. This was renewal, alva?
2004 and 2020 it was not operating. Very same authority. And the authority is discriminating application by applicant. Wherever scheme notification is there, it has to be considered. Section 98 is very much clear. It overrides any provision under chapter 5. There also,
Contested, huh?
Their contention chapter. Yes, the Piano 13 of the tribunal, the contention of the case at this is not to consider.
What is your
Before
contention?
the authority and also before the tribunal.
But your application has been rejected on the ground of delay. Alva.
It has to consider the notification. In of the subsequent notification, the authority has to consider this.
What is that notification?
That is 28
28.
Those permits which are operating as of 21/2002 are exempted and saved under the scheme law.
Where is
That
that
is my representation before the authority, and we have not been considered. That the notification was questioned by KSR. Any notification benefits considered by the RTO only, it is really of the announcement.
Which notification is the 7/3/2019? Have you produced it?
In the first notification itself, my permit is saved and exempted.
28/9/2017. Here, along with the writ petition. Which is that paragraph? Which is that you're reading? Page number?
Considered by authority
Yavude?
and tribunal.
ಏನಿದೆ ಹೇಳಿ? Where is that relevant portion ಓದಿ?
You may kindly peruse. Para 13. Further, as per the section 88 of the notification, page 30. Further,
Page
as per
30, yeah. Whereas? ಎಲ್ಲಿ?
WP 7089, seal number 14.
7089 ನಲ್ಲಿ.
Para 13.
Para 13 of your writ petition, huh?
Oh, yes, ma'am.
Which order?
Criminal order.
ಇದು ಓದಿ, notification ಓದಿ, notification. Page number. Page ಓದಿ.
Page 32, madam. That is regarding the notification. Page 34, annexure E. Notification dated 28/9/2017. There are 6 notifications published by the government under section 102 of the Notification Act. Under these notifications, where my permit happens to be overlapping Bangalore scheme, it is saved under the Bangalore scheme. India permit was operating as on 14/1/2002.
Where is that? In the case of permit holders.
Page is
In case of the permit holders to whom the permits are granted.
39. Relevant page is 39 of my writ petition. Modification of Bangalore scheme.
Yes.
In the principal scheme approved under the subsection 2 of the section 68B of MB Act 1939, while notification dated 7/6/1960 and modified while notification dated 17/1/1996 and notification number dated 28/5/2007. In the entries corresponding to item number 3 after clause C, the following clauses shall be and always be deemed to have been inserted, namely, in the case of permit holder to whom permits are granted and issued by transport authorities and operating as on 14/1/2002, such permit holders are exempted to operate their services on interstate, intrastate, interdistrict and intra-district routes, notwithstanding anything contained in the Bangalore scheme, with the condition that they shall not be entitled to pick up or set down passengers in such portion of the notified road. There is no separate notification.
Correct.
To connect
And,
the same, you may kindly.
What is that 18/12/2014? What is that? What is the cutoff date 18/12/2014? 18/12/2014.
Subsequent notification 7/3/2019.
What is that?
That is one more notification issued by the government on 7/3/2019. Prior notification itself, my permit is exempted and so. To ascertain the same, Malad, page 20.
You had obtained permit in the year 2014 as well.
No, 1998 itself.
See, correct.
But
You
it was not updated after 2004.
correct. It was only valid up to 2004.
Yes.
After that, you have not operated. Correct. And then it seems you had obtained some permit afterwards. Is it so? After 2004, you are not sought for.
By renewal application to obtain my.
When did you file a renewal application?
It can be filed.
Huh?
18.
18/9/2000? 3/9/2018.
Yes, after that notification. 28/9/2017 notification. So other time the allegation of KSRTC women.
See, this all notification are in respect of Mysore scheme, BTS scheme, Kolar scheme, Bellary scheme,
Yes.
Bangalore scheme, and Kanakpura scheme. In the principal scheme approved under subsection 2 of section 68D of the Motor Vehicles Act, wide notification dated so and so, in the entries corresponding to the item so and so, the following shall be and always shall be deemed to have been inserted. In case of the permit holders to whom permits are granted and issued by transport authorities and operating as on 14/1/2002,
Yes.
such permit holders are exempted to operate their service, exempted
Yes.
they are
Coming under that clause.
exempted to operate their services on interstate, intrastate, interdistrict, and intradistrict routes, notwithstanding anything contained in the Kanakpura scheme, with the condition that they shall not be.
One second. Page 20 were kindly request. Page 20. ಗುಂಟೂರೆಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ರಸ್ತೆ ಸಾರಿಗೆ ನಿಗಮ ತುಮಕೂರು ವಿಭಾಗ ತುಮಕೂರು ಪರವಾನಗಿದಾರರ ಮಾರ್ಗವು ಬೆಂಗಳೂರು ಸ್ಥಿತಿಯಲ್ಲಿ ಹಾದು ಹೋಗುವುದರಿಂದ ನವೀಕರಣಾರ್ಜಿಯನ್ನು ತಿಳಿಸಿದರು ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಿಗೆ ತಿಳಿಸಿದರು. It has not been considered by the authority.
See what they say. They say one notification is there. It pertains to Bangalore, Tumkur, not Tumkur, but then other. It is applicable to Tumkur region.
Should be decided by the original authority. Supreme Court also says.
He is not well and you are insisting.
Okay,
What is the judgment for? Yes. We'll take this matter on Wednesday.
Okay. Seat number 15, Harish Bhandari is not there. 12 and
11,
13 and 15, Harish Bhandari is not there.
14.
13 and 15, Harish Bhandari is not there.
Under ನಿಮಿಷ ಹರೀಶ್ ಭಂಡಾರಿ ಅವರು ಇದ್ದದ್ದು ಹೇಳಿ.
11, 12 and 13.
Judgment ಕೊಡಿ, which is the judgment? ನೀವು ಹೋಗಿ ಮಿಸ್ಟರ್ ಭಂಡಾರಿ. Yes. Who is the counsel appearing there?
Government and
Shubham.
advocate has already appeared. He is not representing regularly. And I am saying not for only mandamus there.
Mandamus to whom?
So authority R1 and R2. Karnataka authority.
Have you looked into that writ petitions? ಅದು Wednesday. ಹರೀಶ್ ಭಂಡಾರಿ Wednesday ಆಗ್ಬೋದಾ? It's delay, alva.
Section 98 is overriding that delay chapter 5 also.
Please. ಇದೇನಿದು?
Madam, WP 2338 here.
Mr. SCGP. The initiation steps to consult with the counterpart Tamil Nadu authority to include the additional 2 single trips, counter signature. It is a positive representation of yours. Positive direction kehta idira. You are not seeking to consider your representation. What you are seeking is to consult.
Interstate agreement.
You cannot direct them to. You can give a representation, let them consider and pass order. Then not this phrase.
Since from 2007, my permit is granted in the year under the old motor vehicle act.
Which is your representation? Which is your representation?
J1 and J2.
The grievance of the petitioner is the non-consideration of the representation.
It is already given. There was a contempt petition against the PSC and he has admitted is going to include, but he has to consult with the SPA.
You one helidre you talk so much. You one heli yaudare. You elaborate your submission.
ಅಲ್ಲ ಯಾವುದು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ನಾವು ಒಂದು ಮಾತು ಹೇಳ್ತೀವಿ SPA ಅದು ಒರಿಜಿನಲ್ ಅಫ್ಯಾಕ್ಟ್ ಅಂತಾರೆ ಅವ್ರು ಕೇಳಿದ್ರೆ ಇವ್ರು ಕೌಂಟರ್ ಸೈಡ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ
Consider and pass. The grievance of the petitioner is the non-consideration of the representation submitted by the petitioner to the respondent number 1 and 2. Alva? 1 and 2? 1 or 2 na?
only. That is Karnataka.
And who is to put 1 and 2? As per annexure
J1 and J2.
J or J1? J1 and J2. Dated?
One is first representation, second is remainder of.
Dated 29/6/2022 and 7/12/2022. Then the SCGP submits that if some reasonable time is accorded, the representation of the petitioner would be considered in accordance with. The said submission is recorded. Recorded. The petitioner, the respondent, to consider the representation of the petitioner at annexure J and J1 and pass up strictly in accordance with law and pass appropriate orders within 8 weeks from the date of release of this order. J1 and J2.
Order. RP 221 and 223. Annexure B is the writ petition filed by another revision petitioner, the same common order in RP 128.
Now, what was the permit? Permit was renewed from when to when?
18 to 23.
18 to 23. Reconsider.
Has been restored.
So far as it P8. Idalla. They are relying on another judge. Which is the order? Impugned order?
Section A is the impugned order, common order for various.
Now in this connected review petitions that has been allowed, so similar order has to be passed in similar terms. The 50 remanded aito, come to page 63, 62, 61. This is a petition relates to RP 128 of 2008. So 128 is already been allowed. So similar relief have to be. So, the petitioner is seeking for the following relief. Page 11. Both the council, we'll say both the council have, we'll say that because it's already an order passed. Both the council, the learned council on both sides submit that in review petition in RP 128 of 2018, referred by C. Srinivasa in WP 7130 of 2022 has been disposed of, and the setting aside the renewal of permit granted in favor of the petitioner and the renewal permit in favor of the petitioner by respondent number 4 is restored. Yes, paragraphs.
Yes, respond number 2, madam.
Renewal granted in favor of the petitioner. It has been allowed as under 863. Now, what is your grievance now? What is your grievance in this petition? What is your grievance?
The renewal has been set aside by the tribunal in the common order. And the 128 is seal number 1 in 50, page 57, the common order. That is RP 128.
Yours is 128, huh?
Yes. That is 128, order has been passed in the petition annexure B.
Would submit, both the council submits that the present writ petition needs to be disposed of in similar terms. Yes. What is section 88?
88 is in respect of the interstate roads. Permit was granted under section 88 of the Motor Vehicles Act. Enclave permit.
Section 88 relates to validation of permits for use outside region in which it was granted. Full stop. It states that the permit granted by one regional transport authority is not valid in another region unless it is countersigned by the regional transport authority of the other region, and a permit granted in any one state shall not be valid in any other state unless countersigned by the state transport authority of that other state or by the regional transport authority concerned. The Part 2 of section 88 states where permits granted or countersigned by a state transport authority shall be valid in the whole state or in such regions within the state as may be specified in the permit. The proviso, the second proviso transport authority is concerned. Second proviso states that conditions where permits are valid across state borders, including when both the starting and ending points are within the same state, and a portion of a route extends into another state, provided the distance within the other state is less than 16 kilometers, in this case, as the starting point and the ending point of the petitioner's route are within the same state, and the portion extending into Tamil Nadu is less than 16 kilometers, the renewal of the permit complies with 88(1) and its second proviso, and therefore the tribunal's decision is contradictory to the provisions of section 88(1) of the Act. And the present petition needs to be disposed of in terms of the order in WP 7130 of 2022. And this court passed the following order. The petition is allowed the impugned order dated 27/8/2021 as by the Karnataka State Transport Appellate Tribunal in RP number 125 of 2018 and RP 221 of 2000.
By revision 221 and 220.
125 RP 221 of 2018 and RP 222 of 2018. In so far as it and the renewal of permit is set aside, in so far the petitioner is concerned, is set aside, and the renewal permit is granted to the petitioner by respondent number.
My case is
Respondent number 2 is restored. In so far as petitioner is concerned. Yes. Faster. 4 what happened? You are the standing counsel for the DCVC. So you just get information as to what happened to the application which they have filed, or what happened to the application which was forwarded by them. Your name?
waiver code comes to therefore directs me to refer the
Now that all.
that is required.
Let him get an information. Whatever happens, we can after that. Gautam Ullal, learned counsel, standing counsel appearing for the district caste verification committee is requested. To verify the progress in respect of the letter dated 2012-2017 pertaining to one K.A. Nagabhushana employed in the State Bank of Mysore. And yes, you have already given it. Yes. Copy of the caste certificate letter is enough because if you have a copy of the caste certificate, it's not that that's not available. Gautam Ullal, learned counsel present before the court is a standing counsel appearing for the DCBC. Is that requested to secure the progress in respect of the letter dated pertaining to K. Nagabhushana employed in the State Bank of Mysore. And petitioner to give the details of the letter to the petitioner counsel submits that he has already furnished the details of the letter to the copy of the letter to the learned counsel. Learned counsel Ullal. That is all. Only on that basis you have to see what has happened after that. They have addressed a letter to you. So what has happened pursuant to that? The learned counsel to place on record the further progress. By which date you want? No. 30th. By 30th. Yes, by 30th. What is the objection? To bring the LS of respondent, he has to take notice, right? So this application, what is the office objection? Not serving the copy? Is it the objections regarding not serving of copy? We'll tell him that he is taking notice for them. Learned counsel appearing for the respondent acknowledges the receipt of I-1 and 2 of 2024 and hence office objection stands overruled. I-1 of, why only 2 applications? Delay is not there. I-1 of 2024 is tried to set aside the abatement between the LRs of deceased respondent number respondent. I number 2 is ಬರುವುದಿಲ್ಲ ಯಾಕಂದ್ರೆ set aside delay ಅಂದ್ರೆ 120 days ಆಗಿದೆ 290 days. Rectification counsel for the respondent acknowledges in the The office objection raised by the registry stands overruled as in the instant case, the application is filed within 90 days. 90 days. And question of filing condonation of delay would not arise. I-1 of 2020 and hence office objections overruled. I-1 of 2024 is filed for setting aside abatement. I-2 of 2024 is filed to bring the LRs of deceased respondent on record. Learned Counsel Narasimha Swamy undertakes to file power to the LRs of the deceased respondent. Is not the just informed, but reasons indicated in the affidavit. The application or the affidavit? Affidavit.
Application with it.
Not verifying it is affidavit. Affidavit is accepted. Abatement is set aside. LRs of deceased respondent are permitted to come on record. Accordingly, IA-1 and 2 of 2024 are allowed. Petitioner to carry out amendment and file amended fast. The second matter, 2.1. Order in WP 51 of 2000. ಅದು order in ಎರಡು order ಅದು. ಇದು common order, first. Second, only inherit. The respondent, again, Narasimha Swamy, ಅಲ್ಲಿ the respondent, the proposed respondents are have already come on record in the connected writ petition 28248 of 2018. In light of the same, the counsel appearing for the petitioners in WP 28240 of 2018 is directed to accept notice for respondents in the present petition. Then you must be handed. You just served. So we'll say petitioner counsel to serve the letter along with the caste certificate on the learned counsel. Extra fine. Yes, yes, sir. Now see, if we have to pass an order, we have to say that the termination order is not proper. If you want, if pension has to be granted. If you are ready for some compensation to be paid to them by way of some interim arrangement, monthly.
Sir,
So what is the establishment? Respondent number is what?
Governed by the Government of India. The application form clearly mentioned that you should not how not give you the points on the basis. Like he did not publish, suppress certain information. Later on, when we referred it, we came to know that he was earlier working in the police department as a constable. Then he, while working in the police department itself, he absented there and then started working as a driver in jail. One minute, he did not resign. Then, while working as a driver in jail, he drove rashly and negligently, and then it resulted in an accident in a death of a pedestrian. Then one more accident. Then he left all this and then he tried to join the home guards. All this is the facility. If we had known that it is not just a traffic accident, a traffic violation for which he is convicted. Now we are not even convicted for rash and negligent driving resulting in an accident. Now we are not even the police department, without even informing them, we will not be instructed. Therefore, the entire charges are being improved. If we had known this, I would not have appointed him at all.
Yes. See, on merit, perhaps he would have not. If he would have had some case, I don't think Narayan Swamy would have made this plot.
Why was genocide and we let an independent evidence. The inspector was examined and another witness was examined. All the records were produced.
The tribunal allowed on the basis of independent evidence, that the evidence is then found in the then the tribunal court that the charge is valid to warrant the
The only thing is now he is superannuated. Dismissed. Correct. He has now that he has attained the age of superannuation, he can't get anything anywhere. Indian Institute of not to grant pension. That is what I said. Pension that cannot be granted because you can pay some amount which he thinks it would be a pension for him. He would assume that it is a pension for him.
We did try, but that is not. Now, if some compensation is for pension, that can also not be possible. ನೀವು ಹೇಳ್ಬೇಡಿ ಆಫೀಸರ್ ಏನಾದ್ರು ಬಂದ್ರೆ ಕೋರ್ಟ್ಗೆ I will definitely
Just put-
otherwise not accept.
He knows about it. Karan Swami knows what is the matter. Yes.
ಅವರು ನಾವು ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಸೆಟಲ್ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ, ಅದಕ್ಕೆ that is why we told him. You keep the concerned officer present. So we'll say exploring possibility of settlement. You mentioned it on Tuesday. You mentioned in the first round itself on Tuesday.
ಮೂವತ್ತೇನದ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಇದೆ ಅದರಲ್ಲೂ ನಾನು ಹೇಳಿದ್ದೀನಿ ಬ್ಯಾಕ್ ಪೇಜಸ್ ಒಯಾ ಮೀಡಿಯಾ ಮಾತಾಡೋಣ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಮಾಡಿ ಅದೇ ಸೇಮ್ ಅಂದ್ರೆ ಏನ್ ಮಾತ್ರ
Institution is the same. Rather, misconduct is different. Regularization was the issue.
ರೆಗ್ಯುಲರೈಸೇಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು ಆ ತರ ಆಚೆಯಾಗಿ ಎಷ್ಟು ಮಿಸ್ಟೇಕ್ ಇತ್ತು ಅಂತ ಕೇಳಲ್ಲ ಸರ್ ಸೆಟ್ಲ್ ಆಗಿದ್ರೆ
ಇಂಥ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಎಸ್ after all alla main driver is very important. You don't know the risk of us is there in that car. When you take BMTC, KSRTC drivers in an institution, we also take those drivers here. Accident ಮಾಡೋದು ಪೊಲೀಸಿಗೆ ಏನ್ ಸಂಬಂಧ ಹೇಳಿ? See, accident ಮಾಡೋದು it's on his own accord.
See what are they?
Look at it, how it is. ಅಲ್ಲಂದ್ರೆ ಇದು ನೋಟಿಸ್ಗೆ ಬರ್ತಿರ್ಲಿಲ್ಲ, ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡೋದು ಬರ್ತಿರ್ಲಿಲ್ಲ, ಏನು ಬರ್ತಿರ್ಲಿಲ್ಲ. ಡೆತ್ಗೆ
subsequent amendment that death ಆಗಿದ್ರೆ
ನೆಗ್ಲಿಜೆನ್ಸ್. At that point of time. Misconduct.
Dismissal is not warranted.
As we told, for what reason you require to tell the details of your prior employment is for this reason. It's very important.
ಅವ್ರು ಬರೀತಿಲ್ಲ ಅನ್ನೋದು ನನ್ನ ಕಂಡೀಷನ್.
ಕರೆಕ್ಟ್. ನೀವ್ ಹೇಳಿರ್ತೀರಲ್ವಾ, ನನಗೆ ನಾ ಇಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀನಿ, ಇಲ್ಲಿ ಆಯ್ತು ಹಿಂಗಾಯ್ತು ಹೇಳ್ಬೇಕಲ್ವಾ.
ಬರ್ತಿಲ್ಲ ಅಂತ ನನ್ನ ಕಂಡೀಷನ್. ಏನಂದ್ರೆ ಫಸ್ಟ್ ಏನಾಗುತ್ತೆ ರಿಟ್ ಆಗ್ತಾರೆ. ರಿಟ್ ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ರೆಫರೆನ್ಸ್ ಹೋಗಿ ಕೇಳ್ತಾರೆ. ಅವ್ರು ರೆಫರೆನ್ಸ್ ಹೋಗ್ತಾರೆ. ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ ಮತ್ತೆ 10-4 ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ, ಡೈರೆಕ್ಟ್ಲಿ ಗೋ ಟು ಲೇಬರ್ ಕೋರ್ಟ್ ಅಂತಾರೆ. ಅಲ್ಲಿ ಲೇಬರ್ ಕೋರ್ಟ್ ಹೋಗ್ತಾರೆ 10-4 ನಲ್ಲಿ. ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗುವಾಗ ಬಿಯಾಂಡ್ ಲಿಮಿಟೇಷನ್ 10-4 within 6 months ಆಗಬೇಕಾಗಿತ್ತು ಅಂತ.
ಅದು ಮಾಡ್ತಾರೆ.
ಅದಾದ್ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. again ಮತ್ತೆ ರೆಫರೆನ್ಸ್ ಹೋಗುತ್ತೆ. ಹೀಗಾಗಿ ಇಷ್ಟು ವರ್ಷ ಆಗೋಗಿದೆ ಸರ್. ಸೂಪರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದ ಕಾರಣ. ಇಂಪಾರ್ಟೆಂಟ್. ಅದರಿಂದ ನಾನು ಅಷ್ಟೆಲ್ಲ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೆ.
Tuesday. Dictation for one question.
The main issue is disposed of. Doesn't mean that 33 1 or 33 gets disposed. And already pointed out to the judgment. The fact, my lords, if this is permitted, the effect of this is that any worker who has protection, the concept of protection is that prior permission is required to be taken. Versus approval is post facto after the decision, simultaneous with the decision. If my lord, this is permitted, kind of action on the part of the management is permitted. It means that no worker will have protection. 33(1) is a dead letter law, my lord.
What happened now? 33(1) application was.
An application. The cause of that action arises at a time when I am protected. The inquiry officer passes the report. They accept the report at a time when I am protected. They file a 33(1)B application. Saying that you are a protected workman, so we are proposing your dismissal, awaiting the permission of the court. Then, my lord, they say the main petition is dismissed.
They withdraw that application, right? 33(1).
Please, my lords, the application was withdrawn, my lords.
Correct. That
And
was
the court allowed us to withdraw the application because he ceased to be a protected workman.
How is it?
Different misconduct.
Same, correct.
The same misconduct in which I was protected for.
You were protected in light of the dismissal of that dispute. What happened? They withdrew that
They
application.
do that.
So now what survives is 33(2)B for them to file.
In fact, and what is the consequence of taking such a finding in law?
No.
If I may just submit.
No, we cannot go beyond. No.
This is the interpretation of 33, my lord. Honorable court. If I may submit, my lord, if this honorable court comes to the conclusion that 33(1) can be withdrawn at any stage and 33(2)B can be filed, that provision becomes a dead letter law for this submission. There's no merit because then the management is all the protected work permission applications will withdraw and file a 33(2)B.
Why was 33(1) application withdrawn?
Yes.
No, why
My
was
lord, he ceased to be a protected workman. One is that, my lords, and they have not challenged the order of the labor court, which has said that I can take back the 33(1)B, my lords.
Having no challenge, my
They
lord.
should have challenged that order, my lord.
should have said it, right? 31(1)B was withdrawn in light of.
Specifically
The
say
court
that
order, my lords.
not permitted. I'll show my lordship the relevant part of the petition. I specifically say at that time the cause of action is arising at a time when I'm protected. The consequence of withdrawal will mean that they're going to now dismiss me, right?
No, but seeking an approval application.
Exactly, my lord.
Ah.
That's entirely unscrupulous. Can a management come and say you are protected?
Now, in light of an allowing of their application of 33(2)B does not debar you from making an application seeking claim statement or making request. Then,
But it's technical point, my
no,
lord.
that is not acceptable.
I would urge the court, my lord, that means that 33(1), all the managements go ahead and do this, my lord. What is the consequence of that on 33(1)? Because every single management can say now you are not a protected worker because 1 year period is over.
It's not because of 1 year period is over. No. The withdrawal was on light of if at all 1 period is over, now seeking 33(2)B is something different. But now.
The withdrawal of the main case has no impact on the SLA, which is the judgment produced even at that stage. The fact
See, the question is on withdrawal of 33(1)B, under what circumstances they can withdraw 33(1)B and they can seek for filing an application under 33. They are not converting. No, in this present facts, the case is different. They filed this application for withdrawal of 33(1)B in light of the disposal of the dispute. Correct. Then So that was withdrawn. Then what remained for them is to seek a permission under that. He was not even there as a protected and protected workman.
The fact that anything happens to your main case has no impact. I just hand over this judgment, my lord.
Yes.
I have not been given the copy of the judgment, my lords, and senior has argued this matter. Both the parties have argued this matter in detail, my lords.
Hence, it must be held that an application for approval does not come to an automatic end by virtue of the fact that the main industrial dispute, which has been.
It is not automatic here. They have sought for withdrawal, and then this application has been filed. That's all. Yes. Petitions dismissed.
Much obliged.
Madam, you really argue well. Do this. Keep your work. Good work.
Much obliged, madam.
Yes. Both the petitions dismissed. We will consider. That is the 1B and 2B. I'm thankful. You have given your synopsis, right? Your arguments also you have taken. But same. Next, yes, Mr. Bhatt. We have looked into this entire papers. He is here. No, he was there on VC. Let him come. Let him argue, but you are there. No, you can take notes. 22.2 and 2.3 dismissed.
Yes.
WP 328. No, on merits. 28479 of 2019. That is regarding the change of altering the conditions, right? Transfer was that, right? That has no nexus. The change of condition, alter of condition has no nexus with the misconduct, right? 28479 of 2009 and 2848 of 2022, 2.2 and 2.3 dismissed. Yes. Order dismissed. Yes. Correct. Now you say the domestic inquiry was not fair and proper, right? Yes. Night. Show cause some documents were not given to you, not produced.
It was also I request for study assistance from one of my colleagues who is the field president. That was also not permitted. So then the entire proceedings were conducted in English because that person who had appeared on behalf of the management as presenting officer did not have knowledge of Kannada. So therefore, the entire proceedings were held in English. That is also not admitted by the management committees.
So he has admitted so many things. He has also admitted, but the management had already served you the copy of all the documents. That is
copy was I think possibly related page
210. He says in the earlier portion, I did not give the copy of the charge sheet to opposite party as the management has already given it to the opposite party.
Then I did not give the documents which are marked at exhibit M3 and 7. In the absence of the opposite party, I marked exhibits M11 and 19 on 1699. So in my absence, these documents were marked and not taken into consideration. I did not verify whether the management has served the notice of the inquiry of the opposite party before making.
When the matter was commenced on 23/5/1994, on that day the opposite party was present.
Yes.
Was not present in the inquiry. The date was fixed. So let us come to the first date.
Yes.
That is 15/4/1994. Explanation was sought
Yes.
Correct? Dates correct ಇದೆಯಲ್ಲ check ಮಾಡ್ಕೊಳ್ಳಿ. 15/4/1994.
1994.
That is, he sought an explanation.
Yes.
Short time for explanation. When was the inquiry started? Just give the date. Inquiry started with the date. First date.
That I want to take page 207.
207.
Yes. It is the starting portion of the examination of this extension. Date of inquiry has been fixed on 23/5/1994.
First charge sheet, when was it issued? First date, show cause notice.
Charge sheet is
4/4/94. Charge sheet come notice.
Yes.
And he sought time for explanation. Charge sheet come notice. On 15/4/1994, explanation was, he sought time for offering explanation. Short time by the workman. Then
City was in 23/5/1994.
he submitted his explanation on 7/5/94. Explanation offered. Then 16/5/1994. Notice of inquiry. Informing the date of appearance as 23/5/1994. Inquiry was commenced from that day.
Yes. Then on that day, our ATPS was not present, so it was urgent to 1694.
You did not appear on that day.
Yes.
So you were aware about this date, 23. Did not appear. So one date was given.
That is 1694.
1694. You next date.
Yes.
Then what happened on that date?
Then that day, I was issued with a notice regarding this 1994. If that notice was not served on me and acknowledging it, then the inquiry officer adjourned me to 15/6/94.
So he was absent. You were again absent there.
So that is what can be perceived.
See, all these things, dates, it's very uncommon that he would not know. Having appeared for the first time. If he had not appeared for the first time, then we could have taken that he has not been served with a notice. After once ಬಂದ ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ. We can understand, but see how much we should. And if an inquiry officer has not conducted him properly, misconduct has not been analyzed properly, that is one thing. Principles of natural justice should not be extended to such an extent to say that the person who willfully be is absent to the proceedings be given another opportunity. Change trend alva. That has given a long way now. Natural justice ಸುಮ್ನೆ ನೀವು ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಮತ್ತೆ ಕಟ್ಟಲಿಕ್ಕೆ ಬರಲ್ಲ. ಏನಾಗುತ್ತೆ ಎಷ್ಟೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ they be present. ಆಮೇಲೆ ಬರುವುದಿಲ್ಲ. ಏನ್ ಮಾಡ್ತಾರೆ? Very less for you all. You can't always say principles of natural justice. If you had not appeared in the first instance, the address was not proper, willfully they had evaded all this, then they also, while conducting this inquiry, they will take 100 times so that the order of inquiry officer should not be set aside. 1694 absent.
Yes.
Then the next date, ಮತ್ತೆ absent. ಏನಾಯ್ತು ಅವತ್ತು?
Inquiry did not held ಅಂತ ಹೇಳ್ತಾರೆ. And the same was urgent, whether page 2 or 8 doesn't say that I was absent.
You have that inquiry ಇಲ್ಲಿದೆ records ನಲ್ಲಿ. Inquiry proceedings. Inquiry proceedings ಇದೆ ನೋಡಿ. Annexures and all will be there ಅಲ್ಲಿ. ಎಲ್ಲ annexures ಎಲ್ಲ ಇರುತ್ತಲ್ವಾ?
Order sheet.
Order sheet proceedings ಅಂತ. ಇದು ಎಷ್ಟೆಲ್ಲ ಹೋಗ್ ಬಂದಿದೆ. ಎಷ್ಟೆಲ್ಲ ಹೋಗ್ ಬಂದಿದೆ.
The trivial issue, ultimately the burden is on the court.
We have to, ನೀವು ಹೇಳಿ ಹೋಗ್ಬಿಡ್ತೀರಾ ಆಮೇಲೆ ನಾವು ನೋಡ್ಕೊಂಡಿರ್ಬೇಕು. We were better is that side. No, for you, it is the question of saying that you were not served, but we have to look into all the proceedings and annexed even when they are served. SLA ಎಷ್ಟು ಸಲ ಇದಾಯ್ತು, ಎಷ್ಟು ಸಲ ಇದಾಯ್ತು. ಈಗ 33 2B application has been allowed, ಅಲ್ಲ? You have attended superannuation. Only one. I think this we will hold it as proper. Domestic inquiry held fair and proper. Which is that writ petition?
And 1.1 and 2.2.
That is 2 is regarding domestic inquiry. ಇಬ್ರುದು domestic ಅದರ ಒಂದು ಎರಡು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ಒಂದರಲ್ಲಿನೇ. So inquiry has to be held fair and proper. That is how the tribunal has held. Right? No, because looking into the documents, this court had looked into all the proceedings, what has been transpired. He has not appeared consistently. Then now he comes and says documents was not served. Whereas the inquiry officer, though he did not serve, management had already served upon him. So the question of that inquiry of fair and proper not.
Yes.
Now what is the position of the workmen now? Six. Before. ಈಗ TA ಅಷ್ಟೇ ಇನ್ನು ಎಷ್ಟು ಡಿಫರೆನ್ಸ್ ಬರುತ್ತೆ ಸ್ಯಾಲರಿ? ದೇ ಹ್ಯಾವ್ ಪೇಡ್ ಯು 3,996. 3827 ಅಲ್ಲ 3996 ಅಂತ ಹೇಳಿದ್ರು. No, if Mr. Anand says something about it, now what happens is, now in light of the dismissal, you will be not entitled for any benefits. Neither he would raise any dispute now. Will he raise any dispute? He would not. I mean, in the event this court holds that all the compliance has been done as per 33 QB, Because after the remand by this court, it was reappreciated. Correct.
As whether 1 month's wages is paid or not. So that is the crux of the matter.
Correct. Now 1 month's salary was, 1 month's wages was paid. Where is the finding of the labor code to that effect?
Yes, sir. Please correct the page 165.
165.
Yes. Let's read a couple of paragraphs.
This is the order, impugned order.
But this is one of the impugned orders where the inquiry is said to be parental.
So inquiry we will not touch now.
That issue is over.
So now it has attained finality. When the matter was remanded, it was only in respect of the amount. So inquiry we need not look into now.
Inquiry the other issue will decide management credit. About the
Order of remand ತೋರಿಸ್ತೀರಾ? This court order. ಆಮೇಲೆ impugned order. Or remand ಆದ್ಮೇಲೆ impugned order.
Remand of what is a page annex A, page 121.
A, page 120. This was writ petition by whom their application was rejected.
Yes. There are two petitions, 3116 and 3117 by the management. One wrote ultimately what paragraph 6 at 127. The facts, the error contentions, and the material and data. It is clear after the passing of the order of made an application for a full required and law. Then it was contended that various states less than the actual wages and the point for because there was minimum gain resulted increase in DV, that been obtained prior to the order in the case of the respondents who do not satisfy the requirement of the law. The court, the doctor has recorded a finding in the material on record, but it is priority was due to the respondents the date of the order of execution. What is the amount paid, and if the amount paid is less than the actual salary due to them? What is the amount which was less paid? And these circumstances the improved orders were order. The order the entire matter is related to the investigation without a finding of that. They proceed to consider the case of the and follow the law. All the contentions first, like earlier before criminal and the contentions first from merits.
So domestic inquiry, nothing was passed.
Yes.
So domestic inquiry has remained as it is. But merits ಅಂತ ಹೇಳಿದ್ರತ್ತೆ. Domestic inquiry ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ. So what was open before the tribunal? After this, when was the order passed? 2007. The impugned order. 2007, no?
After this, there was the page on the actual.
After remand.
This again, these approval applications were dismissed on the ground that management did not produce the originals of the result power of attorney that those were involved in the case.
On the round.
Then again they filed a petition. 135 is the second order. Again, the matter was remitted.
Remitted for what extent?
That is with an observation that should be reconsidered in terms of the earlier order. That is by Justice Kumar's order.
Dispose in accordance with law and in light of the direction issued by this court, interpretation referred above.
Yes.
So then give that finding. Yes. Now what is the impugned order now here?
Now, if you got the next
2000.
page 140 annexion again. So this order covers two issues. One is the validity of the domestic inquiry. Then now the second issue pertains to whether this 1 month's wages is paid or not. So both the issues are answered in the next again.
Now, your ground is they have not paid you 1 month's wages.
Yes, sir.
Wages.
But what was my entitlement?
Huh.
Lord,
Where do you find?
I have mentioned Lord, at page 24, I have extracted in the repetition itself. Paragraph 24, page 24.
24.
Page 24.
Correct.
Lord, this amount they were required to tender to me at the time of dismissal.
Yes.
Now, Lord, in the evidence also, Lord, I had reiterated this. Please turn to page 165.
See, this HRA, you are claiming for which month?
But that is for the month of October.
For the month of October. When was the revised HRA?
HRA was not revised. DA was revised.
DA was revised. So HRA is paid. Medical allowance is paid.
It is silent as to whether or not it is paid or not.
Okay, fine. So according to you, this what is paid and what is not paid?
Yes, sir. Now, according to me, this medical allowance was not paid. That is item number 4. Then item number 5, VDA, that is variable dearness allowance for that particular month.
Which month?
That is for the month of October 1996.
VDA is not paid.
It is not paid.
Medical allowance not paid, not paid.
Yes.
VDA not.
Implement of 25 for 3 years. That is 105. Rupees 105 is also not paid. Because I was under suspension from 1994 to 1996. So I was not granted annual increase for 3 years. So therefore, my contention was that I was entitled for 3 years.
Suspension nagidaga increments ಹೆಂಗ್ ಬರೋದು?
ಇನ್ನೊಬ್ಬರಿಗೆ similarly situated employee suspension ಇದ್ರೂ ಕೂಡ annual increment ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಮಾತು ಬೇರೆ. When they are paying you the wages in lieu of this 33(2)(b, ನೀವು ಎಲ್ಲ increment ಕೊಡಿ ಎಲ್ಲ ಕೊಟ್ಮೇಲೆ ನನಗೆ dismiss ಮಾಡಿ ಅಂದ್ರೆ
The discussion is in relation to point. I think tender increase number.
correct.
There are 20 projects. So opposite party will return the order to the case of evidence that is from over national regard to according to exhibit A315.
Just a moment, just. Yes.
According to exhibit A15, the basic pay is rupees 1995, DA is rupees 1705. As per the memo, the HRA is rupees 94 and medical allowance is 72. I have also increased the DA of rupees 124 as of the date of dismissal. I have also to get 3 individuals each in a sum of rupees 35, that is rupees 105. If all these particulars are added, I am eligible for a sum of rupees 4115 as 1 month's wages, but the DD is given to us in the sum of rupees 3983, rupees 173 shortage. The exhibit A50 is the extract of successful balance disbursement register for the month of November 1996, pertaining to Mrs. Reservoir Sugar. In this document, the name of the opposite party Ashok Reddy is stable. His basic and DA are mentioned as rupees 1955 and 1705, respectively, and the state entry is marked as A. For the month of October 1996, the basic pay of the opposite party Ashok Reddy was 1955 and DA was 1705. In the month of September 1993, the DA was based with the state Ashok Reddy was 35%.
This is you don't dispute A15.
A15 not I dispute because that did not contain the details of medical allowance and HRA. As far as not this
But HRA has already been paid to you.
As far as basic and DA is concerned, there is no dispute. Same was the basic and DA for the month of July 1996. For the month of June 1996, basic pay was rupees 1955 and DA was rupees 1551 basis 75 equal to 352675. Same was the basic and DA for the month of May 1996 as we gathered from exhibit. The dismissal of I will speak about paragraph 27, then about the paragraph 28. In other words, we have to compute the wages of the opposite party for the month of October 1996.
The previous month wages has to be paid from October 1996. So that 1 month's wages has to be calculated. Subsistence allowance disbursement registered, the basic of the opposite party for the month of 1996 is this you don't dispute.
That I don't dispute.
So you don't dispute 1705 also.
Yes.
What is this basic pay is 199 plus this DA. Then
the medical allowance.
Then they have calculated here the details of the opposite party. A16. That is 3,722. That is the because this DNS allowance will not be changing or varying every month. It is for the one.
There will be fluctuations every 6 months.
6 months. So as on that date, we have to see January. January nodidre, that same has to be applied here. Ado. Agidya June alli variation agidya. So if you look at this A15 and A16 as well,
Yes.
Weightage kottidare. Weightage they have given you. Variable DA they have given you as on 1/1/1996. And then HRA kottidare. HRA definitely will not be changed.
Cross-examination ಅವೆರಡು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ admit ಮಾಡಿದ್ದಾರೆ. That is the
ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೂನು if it is there on record, what comes to the management's witnesses mind we don't know. He will say anything. ಏನಿದ್ರೂನು ಹೂ ಅಂತಾನೆ ಏನಿಲ್ಲ ಅಂದ್ರೂ ಹೂ ಅಂತಾನೆ. You cannot know his witness. So we have to look into the documents. If it is paid, paid. If it is not paid, not paid. HRA ಕೊಟ್ಟಿದ್ದಾರೆ, ಮೆಡಿಕಲ್ ಅಲೌನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ವೇರಿಯಬಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Sum and substance 3,722 you are entitled to. While mentioning the applicant has paid 3,893 towards 1 month salary. Alva? 3 increments baralla. How are you entitled?
usually maybe ಮುಂದುವರೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಬರೋದಲ್ಲ. That legally you may can urge, but not ಅಷ್ಟೇ ಅಲ್ವಾ? ಆಯ್ತು ಬಿಡಿ. Amount is paid, correct. Amount paid is correct. Now if you look into this aspect, increment not entitled. They have paid the whole amount. ಅವರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿನೇ ಕೊಡ್ತಾರೆ. ಟೆಕ್ನಿಕಲಿಟಿ ಬರಬಾರ್ದು ಅಂತ. We'll take your contentions. But ಇನ್ನೊಂದೇನು? Correct. ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರಲ್ವಾ ಮಾಡೆಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆರ್ಡರ್ಸ್. ಮಾಡೆಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆರ್ಡರ್ಸ್ ಕೊಡಿ ಇಲ್ಲಿ. What is that model standing orders prescribes something different? Model standing orders. Some ಕಡೆ ಈ ರೀತಿಗೆ ಬೇಕು.
Service record should be the extenuating factors that has to be looked into while imposing punishment.
Okay. Ega, we are not looking into the proportionality. We are just saying whether the compliance of 33 to be for seeking for approval.
Monetary benefits if your lordship comes to the conclusion that everything is in
order
in terms of the
compliance
provisions, then that necessity also may not be available.
ಇಲ್ಲ ಬರೋದಿಲ್ಲ.
So of course, my alternative submission is, since Lord we had rendered 8 years of service, unblemished service for 8 years, but that should have been taken into account while inflicting the punishment.
But that cannot be an adjudication under 33 to be ala. Proportionality. The summary proceedings nali, see if you say something about this 33 to be in the 33 to be application about the proportionality of the misconduct and the gravity of charges which has been imposed, then your remedy under 10(4) would go. You would not be able to raise that. If we say that it is just and proper, proportional, it has been proved misconduct, under your all remedy will go.
In the adjudication process under section 11 has no role.
Correct. Illala. That we may not even look into. That is the reason why we should not look into when a summary proceedings has been challenged. The reason is you have a liberty for challenging, and once we say something here, maybe that is not binding, but it will become a binding precedent for the labor court. Ashtena? This is dismissed. WP 12998 of 2008. ಎಲ್ಲರದು ಒಂದೇ charges ಅಲ್ವಾ?
The allegation is that whatever bills which this petitioner had submitted,
both together have done it.
He approved the bills and he processed further. That was the allegation.
Processed further. Correct. Knowing about this bills which has been submitted by the petitioner number 1. Yes. 20. That is what in this 2 petition, if they give you some monetary benefits, now that you have already, the LRs of petitioners are now before the court. 1, no. Otherwise, we cannot interfere. Now, where he file? He'll not even file reference now. We won't. And in this 21, according to you, the charges were not very. He had no main role in this, and the charges which were leveled. Yes, what is that, Mr. Anand? Where is Mr. Anand? No, we are not adjourning after hearing this much. Ask him to. He was there on online. He was there online.
Yeah, Anand.
What monetary benefits you would be claiming?
Just making submission request.
Both petitions dismissed. Dismissed. 2 and 2.1. We'll give reasons for that. You have dismissed the petition. You're new to the bar. You're new to the bar. You're not well. ಏನ್ ಮಾಡ್ಬೇಕು ಮಿಸ್ಟರ್ ಶೇಖರ್ ಅವ್ರೆ? ರೇಣುಕಾ ಅವ್ರು ಬರ್ತಿದ್ರೆ ನಾವು ತಗೊಳ್ಳೋಣ. ಅರ್ಧ ಆಗ್ಬಿಡುತ್ತೆ. ನಾವು ಸ್ವಲ್ಪ ಕರೆಕ್ಷನ್ಸ್ ಮಾಡ್ಕೋತೀವಿ ಅಲ್ರಿ. ಅಲ್ಲ ಕರೆಕ್ಟ್. ಇದರಲ್ಲಿ ಇದು ಮಿಸ್ಕಂಡಕ್ಟ್ ಆಫ್ ಅಬ್ಸೆಂಟಿಸಮ್ ಅಲ್ವಾ? ಎನ್ಕ್ವೈರಿ ಅಪರ್ಚುನಿಟಿ ಅಂದ್ರೆ ಒಂದು ಸಲ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ವಾ? ನಿಮ್ಗೆ ಎನ್ಕ್ವೈರಿ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಂತ ಗುರ್ತು ಅಷ್ಟೇ ಇರುದು ನೋಡಿ ಶೇಖರ್. ಒಂದ್ಸಲ ನಿಮ್ ಗುರ್ತು ಆದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಎನ್ ಎನ್ಕ್ವೈರಿ. ಏನಾಯ್ತು ನನ್ ಮೇಲೆ, ಏನ್ ಮಾಡಿದ್ರು, ಏನ್ರ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರೆ ಯು ಶುಡ್ ಬಿ ಮೋರ್ ಡಿಲಿಜೆಂಟ್ ಅಲ್ವಾ?
Reporting officer.
Management examined who? Who reported about his absence? Enquiry records ಇದೆಯಾ? ಎನ್ಕ್ವೈರಿ ತೋರಿಸಿ. ಯಾವಾಗ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ, ಯಾವಾಗ ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತ ತೋರಿಸಿ. ಅಲ್ಲ ನೀವು ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ಹೇಳಿ ಎನ್ಕ್ವೈರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇರ್ಬೇಕು ನೋಡಿ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡುದು. ಎಲ್ಲ ಒಂದೇ R1 ಅಂತ ಮಾಡಿದ್ರು. ಯಾವ ದಿವಸ ಇದ್ರ ಅಂತ ಹೇಳಿ. ಫಸ್ಟ್ ಡೇಟಾ ಫಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಎನ್ಕ್ವೈರಿ ಯಾವಾಗ, ಶೋಕಾಸ್ ನೋಟಿಸ್ ಯಾವಾಗ ಹೇಳಿ. 20
ನೋಟಿಸ್ ಕಳಿಸಿ ಅಂತ ಮತ್ತೆ ಮುಂದೂಡಿದ್ರು. 28/15 served through security people ಕಳಿಸಿ ಅಂತ ಆದೇಶ ಮಾಡಿದ್ರು. ಆಮೇಲೆ 25/4/15 ಅಪರಿಚಿತರು ಹಾಜರಾಗಿದ್ದಾರೆ.
ಒಂದು ಸೈಡ್ ಇದೆ ಲೆಫ್ಟ್ ಸೈಡ್ ಇದೆ. ಅಪಾಯಕರು ಅವರ ಮೇಲಿನ ಆಪಾದನೆಯನ್ನು ಒಪ್ಪಿಕೊಳ್ಳುವುದಿಲ್ಲ. ವಿಚಾರಣೆ ನಡೆಸಬೇಕು ಎಂದಿರುತ್ತಾರೆ. ಧನಾಂತರ ಅವಶ್ಯಕತೆ ಇದೆ ಎಂದಿರುತ್ತಾರೆ. ವಿಚಾರಣೆ ಅತ್ಯಂತ
25(4) ಏನಾಯ್ತು?
25(4)15 ಆಪಾದಿತರು ಅವರ ಮೇಲಿನ ಆಪಾದನೆಯನ್ನು ಒಪ್ಪಿಕೊಳ್ಳುವುದು.
ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ರ? ಅದೇ ಪ್ರಿಲಿಮಿನರಿ ಕೊಟ್ರು. He said he did not accept the charges. No explanation was offered by him.
ಅವಶ್ಯಕತೆ ಇದೆ ಎಂದಿರುತ್ತಾರೆ. ವಿಚಾರಣೆಗೆ 9
So enquiry ಬೇಕಂದ್ರು. ಆಯ್ತು. ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವಾಗ ಬಂತು? ಅವಾಗ
23/5 ಬಂದ್ರು. ಅದರಲ್ಲಿ ಆಪಾದಿತರು ಹಾಜರಿಲ್ಲ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅಬ್ಸೆಂಟ್ ಅವರು. ಟು ದಿ CSE ಅಬ್ಸೆಂಟ್.
23/5.
ಆಮೇಲೆ
ನೆಕ್ಸ್ಟ್ ನಾನು 13/15 ಆಪಾದಿತರು ಹಾಜರಾಗಿದ್ದಾರೆ.
ಬಂದ್ರು.
ಹಾಜರಾಗಿದ್ದಾರೆ.
ಅಲ್ಲ ಆಯ್ತು, ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ನಡೀತದೆ. ನೀವು ಬಂದ್ರಲ್ಲ, you were present. CSE was present, management witness absent.
ಅದಾದ್ಮೇಲೆ ನನಗೆ ನೆಕ್ಸ್ಟ್ ನಾನು ಹಾಜರಿಲ್ಲ. ಇದು ನನಗೆ ಇಂಟಿಮೇಷನ್ ಇರಲಿಲ್ಲ.
ಯಾಕೆ ನೀವು ಪ್ರೆಸೆಂಟ್ ಇದ್ರಲ್ಲ?
ನಾನು ಇತ್ತು. ಏನ್ ಮಾಡ್ತಾರೆ, ನೋಟಿಸ್ ಕಳಿಸ್ತಾರೆ.
ಅಲ್ಲ ನೀವು ಹಾಜರಿದ್ಮೇಲೆ ಅಲ್ಲ ಕರೆಕ್ಟ್. 13/12/2005 ನೀವು ಹಾಜರಿದ್ರಾ? 13/12 you were present. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ, ಅಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಾ? 4/7 ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ.
ರಿಪೋರ್ಟಿಂಗ್ ಆಫೀಸರ್ ಇಲ್ಲ, ಅವತ್ತು ಕೋರ್ಸ್ ಇಲ್ಲ.
ಅವತ್ತು ಆಗ್ಲಿಲ್ಲ. ನೀವು ಬಂದಿದ್ರಾ ಅವತ್ತು? 4/7 CSE ನಾಟ್ ಪ್ರೆಸೆಂಟ್. ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ವಿಟ್ನೆಸ್ ಪ್ರೆಸೆಂಟ್. ಓಕೆ ಆಯ್ತು ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರಾ?
25/5 ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನನಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಆಯ್ತು, ನೀವು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಗೊತ್ತಾಗಲ್ಲ.
ಅದು ಅವ್ರು ಕಳಿಸ್ಬೇಕಾಗಿತ್ತು ನೋಟಿಸು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಅವರು ಕಳಿಸಿದ್ದಾರೆ. ನೋಟಿಸ್ ಆಫೀಸರ್ ಬಂದಿದ್ದಾರೆ.
ಯಾವತ್ತು ಡೇಟು?
7/15.
ಅವತ್ತು ಏನಾಯ್ತು?
ಅವತ್ತು ನಾನು ಬಂದಿಲ್ಲ. ಅವತ್ತು ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು.
ನೀವು ಬಂದಿಲ್ಲ. ನೋಟಿಸ್ ಸೆಂಡ್ ಮಾಡಿದ್ರು ನೀವು ಬಂದಿಲ್ಲ
ಅಂತ ಅವತ್ತೇ ಬರಲ್ಲ ಸರ್. ಯಾಕಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ಐ ಅಬ್ಸೆಂಟ್ ಫಾರ್ ದಿ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ after 25/7/2015. Now the Rashtrapati take out the cross-examination of management witness. Way 70 easier sentences.
ಹಾಕಿದ್ದೀರಾ? ನೀವೀಗ ರಿಟ್ಟಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹಾಕ್ಬಿಡ್ಬೇಕು. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆಲ್ಲ ಹಾಕ್ತಿರಲ್ಲ, ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹಾಕ್ಬಿಡ್ಬೇಕು. ನಮ್ಗೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡೋಕ್ಕಿಂತ ಇದು ನೋಡ್ತೀವಿ. ಎಸ್ ಹೇಳಿ. 17 ಕ್ರಾಸ್ ಆಫ್ MW1. ಕ್ರಾಸ್ ಯಾರ್ದು? Whose cross you are reading? Cross of inquiry. ಪ್ರಾಥಮಿಕ
ಪ್ರಾಥಮಿಕ ತನಿಖೆಯಾದ ನಂತರ ನನ್ನ ಮುಂದೆ ಒಂದು ಬಾರಿ ಹಾಜರಾಗಿದ್ದ 22 ಸಾರಿ ದಿನಾಂಕ 25/9/15 ಒಂದನೇ ಕಕ್ಷಿದಾರ ವಿಚಾರಣೆಗೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅವತ್ತೇ ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ. ಆ ದಿವಸ ವಿಚಾರಣೆಯನ್ನು ಮುಂದೂಡಲು ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ ಅಂತ ಅನ್ನೋದು ಸರಿಯಲ್ಲ. ಒಂದನೇ ಕಕ್ಷಿದಾರರಿಗೆ ಸಾಕಷ್ಟು ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದು. ಆ ದಿವಸ ಮೊದಲು ಹಾಜರಾಗಿ ನಂತರ ಆತ ವಿಚಾರಣೆಗೆ ಬೇಕು ಅಂತ ಹಾಜರಾಗಿದ್ದೀನಿ ಬಂದಿದ್ದ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಂದೇ ಇಲ್ಲ ಅವರು. ಆ ಕಾರಣದಿಂದ ನಾನು ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ. ಆ ದಿವಸ ದಿನಾಂಕ 25/15 ಒಂದನೇ ಕಕ್ಷಿದಾರ ಮೊದಲು ಹಾಜರಾಗಿದ್ದನ್ನು ಆದೇಶ ಕೊಡುವುದರಲ್ಲಿ ಬರಲಿಲ್ಲ.
ಅಲ್ಲ, ನೀವು 4/7/2015 ಬರ್ಲಿಲ್ಲ, 25/7/2015 ಬರ್ಲಿಲ್ಲ, ಅಬ್ಸೆಂಟ್. ನೋಟಿಸ್ ಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
25/7/15 ನೋಟಿಸ್ ಬಂದಿದೆ ನನಗೆ, ಅದು ಮತ್ತೆ ಬರಲಿಲ್ಲ.
4/7 ಬರ್ಲಿಲ್ವಾ? 4/7 ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಲ್ವಾ?
4/7 ಹಿಂದೆ ಹೋಗಿದ್ದೀನಿ ನಾನು ಹೋಗಿಲ್ಲ, ರಿಪೋರ್ಟಿಂಗ್ ಆಫೀಸರ್ ಹೋಗಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ 25/7 ನೋಟಿಸ್ ಬಂದಿದೆ ನನಗೆ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ
ಒಂದನೇ ಕಕ್ಷಿದಾರರಿಗೆ ಸಾಕಷ್ಟು ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದು, ಆ ದಿವಸ ಮೊದಲು ಹಾಜರಾಗಿ ನಂತರ ಆತ ವಿಚಾರಣೆಗೆ ಬೇಕು ಅಂತ ಹಾಜರಾಗಿಲ್ಲ. ಆ ಕಾರಣದಿಂದ ನಾನು ವಿಚಾರಣೆಯನ್ನು ಆ ದಿವಸ 25/7
ಒಂದನೇ ಕಕ್ಷಿದಾರ ಮೊದಲು ಹಾಜರಾಗಿದ್ದನ್ನು ಆದೇಶ ಕೊಡದೆ ಬರ್ತಿಲ್ಲ. ಆ ದಿವಸ ಒಂದನೇ ಕಕ್ಷಿದಾರ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿ ಇರಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 25/15 ಮೊದಲು ಈ ಪ್ರಕರಣದ ವರದಿಗಾರ ನನ್ನ ಮುಂದೆ ಹಾಜರಾಗಿರಲಿಲ್ಲ. ರಿಪೋರ್ಟಿಂಗ್ ಆಫೀಸರ್ ಫಸ್ಟ್ ಟೈಮ್ after class exam management ರಾಷ್ಟ್ರಪತಿಯಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪುಟ ಆಮೇಲೆ ರಾಷ್ಟ್ರಪತಿಯಲ್ಲಿ ಟೇಕ್ ಔಟ್ ದಿ ಫೈಂಡಿಂಗ್ಸ್.
ಈಗ ಆಫ್ಟರ್ ದಿಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಲೇ ಇಲ್ವಾ ನೀವು? ಮ್ಯಾನೇಜ್ಮೆಂಟ್
16, 17, 18 not applied.
Regulation
23, 16, 17, 18 and 19. CLD regulation, specifically take out regulation, and also 2310 also.
In 2310.
23. 11. Inquiring authority. Inquiring authority shall, if the government servant fails to appear within the specified time or refuse or omits to plead, require the presenting officer to produce the evidence by which he proposed to do the article of charge, and shall adjourn the case to a later date not exceeding 30 days. So recording an order that the government servant may, for purpose of preparing this defense, even if I am not appearing on the day, the inquiry officer after have obtained the proceedings for 30 days, enabling me to declare my defense. It is one aspect of it. Rationally, then to 23:16, even if I am not cross-examined, the reporting officer, they have to have in the proceedings enabling me to submit my defense statement, sequence evidence, plus my arguments as per regulation 23:16. Actually, when you see 23:16, when the case of the disciplinary authority is closed, the government servant shall be required to state his defense.
23:16.
The case of the disciplinary authority is closed. It is closed, mela. And pass model close item. Even if the language set is closed, they have to have an opportunity. Close. The government servant shall be required to state his defense orally or in writing as may be prepared. So the defense is made orally, shall be recorded. The defense servant shall be required to sign the record. In either case, the copy of statement of defense shall be given to the presiding officer if he is appointed.
Yes.
After that, one more opportunity, the evidence of behalf of government servant shall then be produced documents produce 17 but the corporate servant may examine himself in his own behalf if he so prefers. That is just produced by the corporate servant shall then be examined and shall be liable to be cross-examination, re-examination. The examination may be inquiry at that. According to the provisions of the test, 2318 is mandatory that. The inquiry authority may, after the corporate servant closes his case and shall, if the corporate servant has not examined himself, even if I am not examined himself or not stated anything in the law, the inquiry officer generally question him on circumstances appearing against him with evidence for the purpose of enabling the corporate servant to explain the circumstances appearing in the evidence against him. The inquiry authority may, after the completion of the production of evidence, after the presiding officer is appointed, corporate servant permit them to file written deed of their respective cases if they so desire. So, last of the relying 2318 bucket. It is not in dispute that charge memo as per as filed not being sanctioned investigation, the authority has ordered for inquiry. The matter was complete by 4/3/2003. And that said, the petitioner has also responded to present. The state traffic superintendent was examined as NW1. The request of the petitioner, the matter was posted on 11/3/2003 for statement. On 11/3/2003, petitioner has filed a written statement as per aforesaid. Thereafter, the inquiry officer ought to have posted the case for evidence of the petitioner as per regulation 23 of so it is evident from the order sheet maintained by the inquiry officer that on 11/3/2006, matter was reserved for findings. Termination 16, 17, and 18 of regulation 23 of the regulation contain detailed provisions for holding an inquiry. After the case of the disciplinary authority is closed, the corporate servant is equal to state the defense, orally or in writing. If the statement is made orally, it is required to be returned and the spirit of the elected officials to be retained. It is therefore that the corporate servant is required to produce evidence in support of the case. The corporate servant is entitled to examine himself on behalf of the case of the He is also entitled to produce evidence in support of this case, regulation 18 of regulation 23 of regulation provides that the inquiry authority may, after the corporate servant closes its case, and shall, if the corporate servant not examine himself, generally question him on circumstances appearing against him, the evidence for the purpose of enabling the corporate servant to explain his circumstances appearing in evidence.
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಶೇಖರ್ ಅವ್ರೆ?
They have to have given an opportunity, even if I am not appear on the date there.
2 dates ಅಲ್ವಾ?
Last date ಅದು ಮೊದಲೇ on last date of hearing you have to examine the recording officer.
ಅದು ಮಾಡಿಲ್ಲ ಅಂತ your contention.
On that day itself, it was stipulated. They have to have given an opportunity to cross-examine. Or if the management closes the stage, ಇಲ್ಲ 47 ಏನಿಲ್ಲ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿದ್ರೆ, so ಇವರು proceedings 16, 17, 18 ಒಂದು ಅವಕಾಶ ಕೊಡ್ತೀವಿ ಅಂತ ಕೊಡ್ಬೋದಾಗಿದೆ. ಕೊಡಬೇಕಾಗಿತ್ತು. In the present case, it is evident from the records that the inquiry officer has not at all posted the matter for evidence. Thus, there is a clear violation of regulation 17/18 of regulation 23 of regulations. Court below has not looked into the records while answering issue number 1 in favor of the corporation. I want to review that the order of the labor court on issue number 1 is contrary to the records. Therefore, the order of clearly issue is required to be quashed. Hence, that the domestic inquiry held by the disciplinary authority is not very proper. The employer should be permitted to sustain his action by getting evidence preparing before the labor court. The first court told said that no information has been held when employer or employee held by in order to satisfy legality related to again opportunity to employ to advise them before it is open for the employee to advise them for the first time justify absent. So it is open to the employee to advise them. Yes, employees have to not present the highlights are available role there. They are moving to the last minute. Not up to that on last date of hearing, I have not whatever the reason. But the employee officer will have to have update the proceedings. Enabling me to stop examining management. Even if not granted such activity, treated as closed, the management the parties are only law. So they will go to next stage because first statement of the workman. Now
in the event, this CSC was not present on 25/7/2015. On one date, they should have given it for the management to lead his evidence. Alla, ನೀವು present ಇರ್ಲಿಲ್ಲ. So evidence has to be taken as nil. No? Then the management has to lead his evidence. ಇಲ್ಲಿ management evidence ಆಗ್ಲಿಲ್ವಾ?
And the day we have management, we have to record the statement of 20 lakhs.
When opportunity should have been given for you for cross-examining.
But if not given, they have to have given a date for
one date. Please, one date.
2316. 2316 mandatory, 16, 17, 18. Inquiry was closed at the stage of 2315 itself. 16 months got to treated as in trial court for that, and they were not applied for that. Treated as nil. Next stage ಕೊಡ್ತಾರೆ. ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಇದೆ.
ಹೌದು.
ಈಗ ನನ್ನ ಆಪರೇಷನ್ ಕೊಟ್ಟಿದ್ರು. ನಾನು ಡಿಫೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊತಿದ್ದೆ ಏನ್ ಬೇಕಾದ್ರೆ. ನನ್ನ ಸಾಕ್ಷಿಯಲ್ಲಿ ಕೊಡಲ್ಲ ಬದಿದ್ಬಿಟ್ಟಿದ್ದೆ. ಲೇಬರ್ ಆಫೀಸರ್ ನನ್ನನ್ನ ಕ್ಲಾರಿಫೈ ಇದೆ. ಜಸ್ಟ್ ಡೀಟೇಲ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ. In the 2318, they shall mandatory. 2318 is mandatory. They are not equivalent. Next minute, appear minute. Whenever I receive minute, they are there. One date minute, 4715. Both workman and management request not there.
ಅವರು ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ 25/7.
25/7 ಇದ್ದಾರೆ.
There on that date.
25/7 ಇದ್ದಾರೆ. ಮತ್ತೆ first time ಇದ್ದಾರೆ.
Now I was under the impression that on 25/7 he was not present. He was present.
25/7 I am not present.
25/7 you are present. ಇದು ಹೇಳ್ತಾರೆ ನೋಡಿ.
ಮತ್ತೆ ಇದು ಅಪವಿತ್ರರು ಆಗಲಿಲ್ಲ. ವಿಚಾರ ನೋಟಿಸ್ ಜಾರಿಯಾಗುತ್ತದೆ. ವರದಿಗಾರರ ಆಸಿಫ್ ಪಾಸ ಹಾಜರಿದ್ದು ಏಳಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ.
ಲೇಬರ್ ಕೋರ್ಟ್ says you were present on 25/7. ಲೇಬರ್ ಕೋರ್ಟ್ ಹೇಳ್ತದೆ.
ಹೇಳ್ತಿದ್ದಾರೆ ಮೊದಲು ಬಂದಿದ್ರು ಆಮೇಲೆ ಬಂದಿಲ್ಲ. ಬಂದಿದೆ ನಾನು ನೋಡಿದೆ ಅವ್ರನ್ನ, ಅವ್ರು ಬಂದಿಲ್ಲ. ಅದಕ್ಕೆ
What was the misconduct? ಎಷ್ಟು ದಿವಸ? ಆಮೇಲೆ 231 days. ಒಂದ್ ದಿವಸ 2 ದಿವಸ ಅಲ್ಲ.
ಅದು ಪ್ಲಸ್ ಇಲ್ಲಿ ಅದು ಎರಡು ಸೇರಿ
ಎಷ್ಟು ಡಿಫಾಲ್ಟ್ ಕೇಸಸ್, ಎಷ್ಟು ಕೇಸಸ್ ಅನ್ಆಥರೈಸ್ ಆಗ್ತಿತ್ತು? ಹಾ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಅವ್ರಿಗೆ ಕೆಲ್ಸ ಬೇಡ, ಸಂಬಳ ಬೇಕು. ಶೇಖರ್ ಅವ್ರ, ಒಂದ್ ದಿವ್ಸ 2 ದಿವ್ಸ ವಿ ವಿಲ್ ಸೇ ಆನ್ ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ಸ್. ಆಯ್ತು, 1 ತಿಂಗಳಾಯ್ತು, 2 ತಿಂಗಳಾಯ್ತು, 3 ತಿಂಗಳಾಯ್ತು, ಎಷ್ಟು ತಿಂಗಳ? What was he working as? From since how long he is not working? ಯಾವಾಗ dismissal? From 2015, he must be employed somewhere ಅಲ್ವಾ? ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾರ ಈಗ? He was appointed as a conductor, driver. History sheet ಈಗ ನೋಡಿ, absence ಎಲ್ಲ is known, it is known. ಗುರ್ತಿರಲ್ವಾ ಅವ್ರಿಗೆ? ಮತ್ತೆ ಅದಕ್ಕೆ ಯಾಕೆ ಮತ್ತೆ ಪ್ರೂಫ್ ಅದಕ್ಕೆ? ನೀವು ಅದಕ್ಕೆ ಇದು ಡೊಮೆಸ್ಟಿಕ್ ಎನ್ಕ್ವೈರಿ ಮೇಲೆ ಸ್ಟಿಕ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಅದನ್ನು ಅದೇ ಅದರಲ್ಲಿ ನಿಮ್ಗೆ ಗುರ್ತಿಲ್ಲ, ಮಾತು ಬೇರೆ. ಗುರ್ತಿತ್ತಲ್ವಾ, ನೀವು ಆಬ್ಸೆಂಟ್ ನೀವೇ ಇರೋದು, ಬೇರೆ ಯಾರು ಆಬ್ಸೆಂಟ್ ಇರ್ತಾರ? ಈ ಗೌರ್ಮೆಂಟ್ ಜಾಬ್ ಸಿಗೋದಂದ್ರೆ ಎಲ್ಲರಿಗೂ ಸಿಗಲ್ಲ. When you have given an opportunity, when you have given an when you are given an opportunity, you should utilize very nicely. ಡಿಸ್ಮಿಸಲ್ ಆಗೋ ತನಕ ಕಾಯ್ಬೇಕಾ ಪಾಠ ಕಲೀಲಿಕ್ಕೆ? 81 ಏನ್ ಹೇಳ್ಬೇಕು? ಅಲ್ಲ, ಏನ್ ಹೇಳ್ಬೇಕು ಇವ್ರ ಶೇಖರ್ ಅವ್ರ?
ನಿಶಾನೆ 2 ಇತಿಹಾಸ ಪಟ್ಟಿಯ ಗಣಕ ಪ್ರತಿಯನ್ನು ದಿನಾಂಕ 29/5/15ರಂದು ಎದುರದ್ದು ಎದುರಿ ನಿಶಾನೆ 2ರ ನಕಲನ್ನು ಉತ್ಪಾದಿತ ನೌಕರಿಗೆ ವಜಾ ಆದೇಶ ಮಾಡುವ ಮೊದಲು ಕೊಟ್ಟಿಲ್ಲ. ಉತ್ಪಾದನೆ ಪಟ್ಟಿಯನ್ನು ಸಹ ಅದನ್ನು ಪ್ರಸ್ತಾಪಿಸಿಲ್ಲ. ಅದನ್ನು ವಿಚಾರಣೆಯಲ್ಲಿ ದಾಖಲೆ ಅಂತ ಗುರುತಿಸಿಕೊಂಡಿಲ್ಲ. ಎದುರಿಗೆ ಕೊಟ್ಟ 2ನೇ ತಿಳುವಳಿಕೆಯನ್ನು ಸಹ ಇತಿಹಾಸ ಪಟ್ಟಿಯ ಬಗ್ಗೆ ಪ್ರಸ್ತಾಪಿಸಿಲ್ಲ. ಎದುರಿ ನಿಶಾನೆ 2ನ್ನು ಈ ಪ್ರಕರಣಕ್ಕಾಗಿ ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡದೊಂದು ಆಯೋಜಿಸುತ್ತೇನೆ ಅಂತ ಸರಿಯಾಗಿ ಕೂಡ ಕೇಸ್ Before we close, it is necessary to make one point clear. It is suggested that the past record of the government service, it is intended to be relied upon for imposing a punishment, should be made specific charge in the first stage of the inquiry. And if it is not so done, it cannot be relied upon after the inquiry is closed. The report is submitted to the party entitled to impose a punishment. Enquiry against a
ಇದು
government.
ಹಿಂಗೂ ಇದೆ ಪಾಸ್ ಕಂಡಕ್ಟ್ ನೋಡಬಾರ್ದು ಅಂತ.
ತಾಪಸ್ಗೆ ಕೊಡ್ಬೇಕು ಅವ್ರು ಹೇಳ್ಕೋಬೇಕು.
ಅಲ್ಲ, how can it be see, one thing is ಇವೆಲ್ಲ ಚಾರ್ಜಸ್ ಏನ್ ಇರ್ತಾವಲ್ಲ, he is aware about all the ಅಲ್ಲ law, correct, you are absolutely right, but it is if in the circumstances is unaware. ಒಂದು ಎರಡು ಇದ್ರೆ ನೀವೆಲ್ಲ ಹೇಳ್ಕೋಬಹುದು. 25-30 ಚಾರ್ಜಸ್ ಇದ್ದಾಗ ಎಷ್ಟು ಇಂಪೋಸಿಷನ್ ಮಾಡಿದ್ರ ಅವಾಗ ಪೆನಾಲ್ಟಿ? ಸಣ್ಣ ಸಣ್ಣ ಮೈನರ್ ಇನ್ಕ್ರಿಮೆಂಟ್ ಎಲ್ಲ ಮಾಡಿರ್ತಾರೆ, ಫೈನ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನು ಸುಧಾರಿಸಿಲ್ಲ ಅಲ್ವಾ ನೀವು?
ಏಜ್ ಆಗಿದೆ.
How much is his age now? He is present. ಇದೆ ಸರ್ವಿಸ್. Heard the learned counsel for the petitioner in part. Part in a heard and to hear the respondent counsel. This matter on Wednesday. Adon judgment. ಇದರದ್ದು ಇದು
ವರ್ಷಗಳ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಎನ್ಕ್ವೈರಿ
ಅಬ್ರಪ್ಟ್ಲಿ ಇವೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 17 and 18
ಎಲ್ಲ ಇನ್ ದಾಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂತ ಇರುತ್ತೆ. ಇದು ಲೇಬರ್ ನಲ್ಲಿ ಹಿಂಗೆ ಫಿಕ್ಸ್ಡ್ ಲಾ ಅಷ್ಟೇ, 33(2)B ಅವೆಲ್ಲ ಸೆಟಲ್ಡ್. ಬಟ್ ಇನ್ ಸೋ ಫಾರ್ as enquiry different. All depends on facts. All depends on facts.
That after the order was passed by the inquiry officer, effectively Caste workman indicated that the deputy inquiry. The inquiry officer closed the inquiry by observing that the inquiry is concluded. It can be witnesses in the inquiry and the deputy workman would view the inquiry and return from participating in the session. Let's conduct at time into the heat of the moment and can be termed as being an impulsive act. Is not enough to conclude that the prosecutor attended the inquiry never intended to participate in the inquiry any time thereafter. What is available is that these perpetrators in the inquiry officer must act hastily and in order to demonstrate that the inquiry is being conducted by hearing to the respective representative, he could very well force the inquiry on some other day and direct the manager to intimate prosecutor workman of the state of inquiry. With the passage of time, there is a possibility that the prosecutor workman would cool down and would reappear in the inquiry at the next day. The inquiry officer took the talk freely. The instant case appeared that the inquiry officer concluded the inquiry. The moment the officer left the inquiry, observed that no evidence has been laid by it. Within 48 hours, the report of the inquiry officer is tendered to the manager. Here we have the contention of the inquiry officer. Is that inquiry was done is that, but what in the class examination mistake. Even assuming that movement may not have done it, whatever it is, how much inquiry Mr. Brazil after?
Wednesday. With the notes after that. ಬರ್ದಿದ್ದಾರಾ? ಅಲ್ಲ. For reporting, sir. Yes. It's not a labor day, but then if it is only for settlement, 5. 20.